Gigi is a transgender student born biologically a girl, but has identified for a while as a boy, and wanted to use the bathroom that boys use. The school board initially let him do so, but then after complaints from parents reversed that decision and said that he has to use an individual bathroom stall. And so eventually he sued the school board on that decision. The federal district court initially ruled for the school board, and the Fourth Circuit reversed on the basis of the guidance that the education department had submitted. The Trump administration withdrew the guidance on transgender bathroom access that the Obama administration had put in. So at this point, it's left to the local school boards until and unless the courts decide otherwise. This case is all about who interprets the statute, who gets to make the decision ultimately about which bathrooms get used and which sorts of facilities can be segregated by sex. Is it Congress in its statute? What if Congress hadn't contemplated it and the statute doesn't provide for it? Can an agency make up its mind in the first instance? What role do courts play? The Supreme Court vacated the lower court opinion and sent it back to the Fourth Circuit to decide the outstanding Title IX issue. And that is, under Title IX, where does gender identity fit? Is it part of sex, or does it not fit at all? Title IX was enacted in the early 70s to ensure that women had the same educational opportunities as men. It prohibits different treatment of men and women in all sorts of educational programming. Now, there's an exception for certain kinds of facilities: locker rooms, bathrooms, showers, and sports teams. And the question, therefore, in this case is how transgender students fit in. This is the first time that the issue of gender identity in the context of Title IX sex discrimination or segregated bathrooms has come up in federal litigation, at least seriously up to the appellate level. And it could well be that we'll see this case up again at the Supreme Court after the Fourth Circuit rules. And of course, Congress can step in at any time to specify what Title IX means in this area. And at that point, we could see a constitutional challenge. Does the Constitution allow whatever result Congress comes up with? Gigi's best argument is that sex includes gender identity. That is, it doesn't matter what DNA says at a molecular level. At the end of the day, XY or XX chromosomes are less important than social understandings. If you present as a certain gender, if you feel that you're a certain gender, then there's really no reason to prevent you from using the facilities that are assigned to that gender. Gloucester County would say that Title IX is silent. Congress did not instruct anybody on how to treat gender identity, and so until it does, it's left to the decision makers on the ground, the school board and the principals, to set policy that makes sense for their communities.